its first public panel on the right to education as part of this conference on social and economic rights. We are very privileged to have a extremely distinguished panel of speakers here today, covering a wide range of both expertise and experience in the area of education as well as litigation in social and economic rights. So I'm going to just give a very brief introduction to everyone so that we have, not to cut into the time for the speakers. Lucy Williams, who is also one of the, I think, organizers of this conference. Welcome to you. She teaches in the area of social welfare law and civil litigation at Northeastern University. She's also co-director of the program on human rights and global economy and the convener of the International Social and Economic Rights Project. She's published widely in various law journals and has a great deal of experience on this issue. Also with us is Dr. Govinda, who was just retired as the Vice Chancellor of the National University of Education Planning and Administration. He has many years of experience on education, both from within the state, working as part of various government committees and bodies, as well as in terms of the research he has been involved in. Welcome, Dr. Govinda. Esteban Hoyos, who is a lawyer and has been working on the issues of constitutional law, especially Colombian constitutional law. He also has been professor of law at the IFIT University in Colombia. Welcome, Esteban. Jaina Kothari, who is a founder member of the Center for Law and Policy Research in Bangalore. She has also been, working in the as a lawyer in the Supreme Court, and is a partner in a law firm in Bangalore, practicing in the High Court of Karnataka. She has also recently been doing a lot of work on social and economic rights, and particularly the right to education, and will be able to give us some specific insights into some of the issues regarding education in the courts in India. So welcome, Jaina. Also with us is Annie Namala, who has, again, many years of experience working on issues of social and economic inequities, particularly related to the Dalit communities in India. She is as an activist and an executive director of the Center for Social Equity and Inclusion. She was also a member of the National Advisory Council for the RTE when the RTE Act was first formed, and has worked in various capacities, both with the government as well as in civil society groups. So welcome, Annie. And with us is Kevin Murray, who is the Executive Director, Program on Human Rights and the Global Economy, also at the Northeastern University School of Law. He has several decades of experience in leadership and advising positions within the international development and human rights advocacy organizations. Welcome, Kevin, to the panel. I will try not to take too much time, but I thought what I would do is to sort of place the issue of education, or public provisioning of education in India, in the larger social and political context, and to give a sense of how the right to education per se has evolved within India, and how it is placed today in terms of its adjudication in courts as well as its enforcement through the executive arm of the state. So when the Right to Education Act was passed in 2009 and finally came into effect in 2010, there was in general a lot of sort of jubilations, but particularly among civil society groups and activists, that finally there was a justiciable right, finally there was a legal entitlement, and that somehow all the problems that had been faced for more than half a century would be resolved because there was this legal entitlement that people had. But in effect, that didn't really happen. It's now almost 6 years since the act was passed, but we've seen very little action, so to say, particularly very little action in the courts. And so that has raised some very sort of fundamental issues regarding, on the one hand, even the enshrining of social and economic issues in the framework of rights, and something that Namita mentioned in the morning. I think that is something that has been questioned by many people, is whether we really needed a right, and what difference has having a right or a legislation made to the actual delivery of education, or the receiving of entitlements by citizens on the ground. It has also raised a lot of questions of in terms of the role of the different arms of the state. So up up until now, it has essentially been the bureaucracy or the executive arm that was involved in the delivery of education. But now that it is so-called justiciable and in the framework of a right, there is also the implication of the judiciary. But how the judiciary interfaces with the executive, or what exactly is the role of the judiciary in the delivery of these rights, is not very clear at all. And I think that's a question that we are confronting, and I hope that in this panel today we'll be able to deal with it more directly. But that's also been something that has it raised a lot of questions also about things like the separation of powers and how much can the judiciary do and how much of an interventionist role can it play. And it's also in the context of the fact that the courts in India have been seen to be extremely interventionist and proactive, and perhaps there is even a backlash within the courts about their very proactive role in terms of the social and economic rights, and therefore we see some of that played out as far as the right to education adjudication is concerned. So where does one go from here, and how even does one deal with the idea of the separation of powers, and how real is it, and what does it mean in terms of some of the human rights, especially from the point of view of the citizens who need the right to be delivered no matter which arm of the state does it. Finally, I think that there are a lot of questions have also been raised in terms of the role of various non-state actors, because you have the state and the different arms of the state, but there is a very active role, and I think most of the experience from other countries also speaks to that, the role of civil society in actually bringing, and of course of the public interest litigation, of bringing courts and cases to the courts and assisting in a sense in that process of adjudication. But there's also been a lot of questions in the Indian context in terms of the role of the private sector, because the constitutional amendment that before which the act was passed actually leaves it open for even private or non-state bodies to be involved in the delivery of the right to education. But to what extent this horizontality actually applies, and what it means for the accountability of the private sector, and what they can do or cannot do, what is their obligation, these are all questions that have yet to be resolved. And given in the context of the fact that in India the private sector is playing a larger and larger role, and in many ways also the state is inviting the private sector to play a larger and larger role, what does it mean for the actual obligations the constitutional obligations of the state in terms of education, I think are questions that we are still in early days of grappling with. So very quickly, let me just make a few comments on where I see education per se located within the social political context. I think one of the big curiosities for me, as I have worked in the education sector now for several years, has been the fact that while we have a very robust sort of civil society and a lot of active social movements and a history of social movements, whether it is gender, labor, hunger and food, or even in terms of the left political parties which have been fairly active in many states, education is not an issue that has been centered or fronted by any of them. Somehow or the other, that has not been an important issue for any of these social movements. We have had a lot of civil society groups working on education, but most of them have been linked really to educationists who are located typically in universities and in the state capitals, etc. And so there's been a lot of work that has been done within education on pedagogy and development of textbooks, curricula, etc., but not as much kind of activism that one has seen in other areas from civil society, which have challenged the boundaries of state and citizen, which have pushed the states for basic entitlements on the ground, and have come up with a lot more sort of creative and other means in which to do so, like social audits, etc., which have become very popular in recent times in many areas. But education hasn't seen that kind of it hasn't taken on that kind of form of social movement. So that has also affected in the way in which the right has been translated on the ground. So it hasn't, the groundswell that one might have expected after the right was passed is not evident as much as one would imagine or one would have hoped for. It is the second. So the second point that I think that is important also to bear in mind is that education has been it's an issue that has somehow not had public provisioning, particularly, is an issue that hasn't had the kind of acceptability amongst large sections of society, particularly the more elite sections of society, again, as one might have expected, given the development, the current state of development of the country. I mean, the kind of social contract that one sees between the state and society in the provision of basic services like education doesn't quite exist in India. And this was evident right from the beginning when the constitution was drafted and education was not included in the fundamental rights. And later on, as education, the demand for education increased, we have seen massive exit of the elite and the middle classes from the public provisioning of education, leaving the government-provided education system to be essentially patronized by only the poor and the socially marginalized groups. As a result of which, the voice from within the education sector has been highly constrained, and so that has also affected the manner in which. And so, right now, the reality is that the right to education, in fact, is for the kids who go to government schools, and they have very little voice and very little resources in terms of actually demanding their rights, whether it is from the executive or it is through the courts. And that is something that I think is often not understood, particularly in international context, because the middle class and elite are really not interested in the government schools and therefore in the right to education. And in fact, whatever litigation that we've had has been to try and keep the private sector and the kids who go to the private sector completely out of the purview of the RT Act. So I think what both of these points actually have sort of led to is a kind of a situation where essentially the the idea of education now being delivered as a right and not just being enforced as a kind of scheme or program of the government, where the citizens or the children in this case are they're not seen as rights holders, but they're seen still as kind of beneficiaries of the government's largesse in a sense. It's just a program that the government runs. In fact, the RTE is implemented through the original program, which is the Sarva Shiksha Abhiyan, or the Education for All program that the government ran even before the RT Act was in place. So very little has changed in terms of the administrative structure which actually delivers education, even though there is a so-called paradigm shift now in the way education is to be perceived even within the government. But no, so in terms of the resources, whether it is financial resources or in terms of human resources that should have been put into place, particularly closer to the citizens, where violations might be noticed, haven't been put into place because the government is still in a very different sort of mindset and not very clear on what it means within the executive to enforce a right. And I think the whole sort of understanding is that if it's justiciable, then this is something that the courts will do. But this is what we do, and we'll continue to do what we do and how we know it, how we know to do it. So there's been very little change in that, and that has really had a big impact in terms of how, on, for instance, the grievance redress situation. It is also a reality that when the drafters of the Act neglected to include a robust sort of grievance redress mechanism in the Act itself. And that is also partly a result of the fact that people who wrote the Act actually are not those who send their children to government schools where these kind of violations that one might expect take place. So there has been a complete neglect of that whole aspect. And also because somehow grievances and their redressal has been thought of as something that will happen through the courts. So within the executive machinery, there is absolutely no grievance redress mechanism. As a result, citizens, in fact, have no other option but to try and go to court. But as we know, accessing courts and accessing the judicial system is an extremely difficult process. First of all, you can only go to court at the high court level is the earliest point at which you can go to, because this is the nature of the fundamental right. It can only go as in the form of a writ petition, which can only be filed in the high court. But accessing the high court for the majority of people who send their children to public schools is almost an impossibility. So the only option then is to go through a facilitating agency of some kind of an NGO that might file a PIL, etc. But again, having access to an NGO or the legal kind of counsel that will assist in that process is extremely limited. So the legal route is actually extremely limited as of now, and I think that is something that one has to think about. It's also very expensive, it's very time consuming, and with education, time is a crucial variable, because if you lose a year, 2 years, it really means pretty much the child is out of school. If he or she is a dropout child, very difficult to get them back to school. So all of these reasons have mitigated the use of the judicial option, and but there is no other option either, because as I said, the executive hasn't put into place a grievance redress mechanism. So as a result, this act really has become, as is now commonly known, it's a right without any remedies. No remedies coming from the courts and no remedies within the executive system as well. But because of the difficulties I mentioned in terms of the judicial remedies, I think there is a lot of work that is being done, or it's attempting to be done. It's early days to try and push the bureaucracy to have a kind of a grievance redress mechanism. There have been, I mean, I know that when I was at the National Commission, we drafted rules for grievance redress, and they've submitted to the ministry. They were even accepted, but no action has been taken on that. There is a little bit of resistance, I think, at that level, because it would mean that the ministry has to sort of take action in a lot more quicker and in a systematic way than they are actually able to. So I think some of the problems also arise from the fact that there is no political will backing this act. There are no resources that have been put into place. So the ministry is very reluctant to have a grievance redress mechanism because they really don't have the resources to be able to implement it. So some of the problems that we are facing are really at a very elemental and early levels in a sense, and will require a push or a pressure, not just at the level of the courts, but I think equally, if not more, at the level of the bureaucracy, so that ordinary citizens can actually at least have some of their day-to-day violations addressed without having to actually go to court. But I'm not going to say a whole lot more because I think the panelists have a far greater experience and expertise on each of these issues, and I will now hand it over to them. And we will start with Professor Govinda, who has been very actively involved not only in the drafting of the Act, but subsequent rules and guidelines, and has, I'm sure, wonderful things to say. Thank you.
Thank you, Kiran. Thank you for giving me this opportunity. I am very happy that we are discussing about RT as a fundamental right, because much of the discourse that has happened during the last few years since the RT Act came into operation, including a lot of litigation that have gone, they have all been focusing on specific sections or clauses and provisions in the Act, never seen as a fundamental right what it is. It's like any common law, this section I am attacking, this is not being done, like 25% reservation. Recently I was talking to people from Karnataka. I was told that almost all things that have been referred to, the notifications that have come from government of Karnataka has been referring only to the 25% reservation. There is no notification from the state. So I am very happy that we are taking a more fundamental issue, the basic issue that education as a fundamental right, what it is happening or not happening, not about the specific clauses of this. Now, yes, with the RT, particularly with the 2002 amendment of the Constitution, it has formally become a fundamental right. Although in 1993, Supreme Court already decreed that it is a fundamental right. You cannot really escape, although it is included in the directive principle. It is a fundamental right, and because you cannot have a life with dignity without education, and therefore it is treated. I was talking to people who are associated with this once when the 2002 amendment was done, and they said, I said that your position seems to be vindicated that the Parliament has adopted this amendment. They said not necessary. It was not necessary, because we would have liked that more people had come to Supreme Court asking for clarification rather than giving it to the hands of the government to really do it. This is what somebody said. I do not know whether it really is coming true or not. Coming to this, the specific issue, as Kiran said, that the education is seen as part of the basket of social and economic rights. We know the world over, implementing social and economic rights has never been an easy, straightforward affair. It is not at all, because even the Covenant on Social and Economic Rights, social, economic and cultural rights, very clearly says that the onus is on the state, and it also says onus is on the state because implementing social rights requires resources. It's contrasting it with the civil and political rights, which are the fundamental rights. This way, some people categorize this as the first generation rights and second generation rights and third generation rights as the development rights, and this as the second generation rights. or some people classify it as red rights and blue rights. The point is that it is always recognized that it's not a very straightforward affair because it requires resources. Having said this, now in Constituent Assembly debates also this came up, that to include education as a fundamental right. But finally, the Assembly members decided that it will not be included in the chapter on fundamental rights, but it will become part of the directive principal rights. And therefore, the reason that was given was we don't have resources. I'm talking of 1950. We didn't have resources. Now, when 2002 amendment was done, we should assume that the Parliament settled that question and decided that we have resources. Otherwise, there was no need for amendment. There was no scope for amendment to be made. So when the amendment was made, that it was assumed that we have resources, very rightly so. We are growing. We are one of the fastest growing economy in the world, after all. And so we thought that we are good enough and we have enough resources. Having accepted that position, where are we? Having accepted that now, probably we have enough resources and therefore let us make it a fundamental right. Is the question why I'm saying this is that was it a well thought out phenomenon or it was only a political gimmick? I do not know. It was only a political decision that was made, or it was a well thought out decision made. I am saying this because a lot of discussions, why after 2002, why did we take 7 years before a legislation came? In fact, some people even question, do we need a law? If it is a fundamental right, why did you require, why was that line added at the end in the amendment as the law, as may be determined by law? And so that it left it open that the government can again come back and then say pass a law, and then the Parliament will pass a law, and then only it becomes operative. Right or wrong, I do not know. Somebody else may be able to tell us more about whether a law was required at all. But what does the law do? The law was, it was explained to us that the law, when we were formulating the things, law is necessary because a law would determine the boundaries of the operation of the fundamental right to education, because it is dependent on resources. One cannot just like that open it up. We need to put certain limits in terms of what is available and what cannot be made available under this. So the resources were considered, therefore, we should assume, because 2002 the law was passed and the first draft of the legislation was ready in 2005. I will come to that because I was very actively involved in formulating that legislation in 2005. Now, although I got associated later on also, particularly 2005. One of the main thing that came was that should we not have a financial memorandum? Since it is a social right, since it is dependent on resources and state owns the resources, therefore should we not have a financial memorandum? We did prepare a financial estimate also at that point of time. In fact, since NUPA was involved in preparing this, I was actively associated with it. We came up with 3 scenarios in terms of if fundamental right, and then if we want universal elementary education for all between 6 to 14, what does it cost us? Under what conditions, what it costs. In 3 different scenarios we built, and we submitted this to the, as a part of the committee's report to the CABE, the Central Advisory Board of Education, to see, and whatever is appropriate, adopt this. Finally, we know that the legislation, when it was adopted in 2009, no financial memorandum was adopted. It came without that. This could be one of the reasons why we are not able to really do this. Now, there are 2-3 things that we need to really see. We should not forget that this amendment became possible because of another amendment to Constitution that was done in 1976. 1976, an amendment was made to Constitution making school education, bringing school education into concurrent list. Till that time, it was the state list. And central government, Parliament could not have passed a law overruling, probably, I do not know, you may be able to tell better, what was included in the state list. So the 76 amendment and this came together. In a way, these are very dependent on each other. Why this is important? Because who is responsible for the center and state? I will come to that little later. This is a very important event that happened. Second, we should also consider that compulsory education acts already existed in all the states. The full hue and cry was that when I started studying education, when I found that when it was explained to me, people don't send their children to school, or the universalization is not happening in 1970s, I am talking, because Compulsory Education Act is not enforceable, it is not justiciable. Now, the question is that now when it became justiciable, can we really forget the history of Compulsory Education Acts existing in the states? We seem to have really washed away all of that Compulsory Education Acts and brought one act above that from the center. I think these are very important events that we need to happen, could be influencing what happens afterwards, if you look at. Having said this, now come to one of the point that is in fact Kiran mentioned also about implementation of the Right to Education Act, whether it is legislation or whatever you are talking. In fact, the 2005 legislation draft that we prepared had a very strong independent section on National Commission for Elementary Education. We had at that time foreseen that the implementation would be very, very difficult proposition, and therefore it is necessary to have an empowered commission at the national level, which would submit a report to the parliament every year, answerable to the parliament, and it will be an empowered commission who should be able to call upon the state or any other body involved in implementing elementary education to really do what should be done. This is what was thought in that. But we know that in the 2009 legislation, when we came, this was all diluted, and a small section was created, one clause was created, and the responsibility was given to National Commission for Protection of Child Rights, NCPCR, which is not part of the Education Ministry, which is part of another ministry. We know the story that it has not happened. NCPCR could never do, because neither they had the money nor they had the mandate to really, except for this, a very oblique mandate from some other law, some other department, but not from their own department. I think this is a very important, again, an issue that has really affected the implementation of the law. Now, I'll come to the last part in terms of since it is on litigation that we are talking about, where do we go from here? If a state establishes a law, establishes a fundamental right, and the state decides not to honor that right, where do we go? This is not like this is a child right. We should be very clear about this. This is a child right, not like other social rights even. It's a right of a child. A child cannot go to the court on one's own. Somebody else has to represent the child to go to the court, even if you want to. So this is not a law where we can only look at restoration of something that has been violated, but it is a law which has to be proactively provided by the state. Now, in this case, if the state doesn't do, where do we go from? So as Kiran said, that everybody looks to the court. The Supreme Court particularly, because Supreme Court is the highest, the body finally who should adjudicate all the fundamental rights in this country, and therefore people look to the Supreme Court to really do. Can the Supreme Court really do? Now, what is it that we need to really look for if you go to the litigation part of it? As I said, since the limits are placed by the law, the boundaries for what is available in the name of the right to the individual citizen is placed. One of the major part of it is actually the schedule that is attached to the act, which actually tells what are all the, in a way, it determines the entitlement of every child. What is entitlement of every child in the act is placed. Now, we know that the DICE report, the statistics in this country, the official statistics of the country tells that not even 10% of the schools in this country really are compliant with some of the selected indicators under the schedule. Selected, not all indicators even, and not even 10% of the schools are, no. Where do we go from here? How do we really ensure that the state really acts on them? I think is the question. I do believe, since the state committed that we have the resources, after so many years, after more than 50 years, we passed the law saying that we have the resources, made the amendment. uh, is bound to really do. How do we really make the state to work? I have no idea. There is no magic wand for the state to work. States everywhere. When, I remember, somebody attributed this to, it's attributed to Gandhiji. Gandhiji was addressing a big rally. I'm told that the Nehru and other people were also next to him. And Gandhiji said, beware government. Sarkar se bach ke raho. This is what he said. So then people sitting next to him, Bapuji, ye hamari sarkar hai. This is our government. Why are you saying this? This is not the colonial rulers. This is our government. He said, yes, we have to really be still, because if somebody an outsider, you can call them a tyrant and tyrannical. But what will you do if our own government turns tyrannical? We need a strong civil society. I am telling the people, you have to really fight for your right. I think this is whether it is really Gandhiji said or not, this is what I heard about. I think it's a very, very important point that is being made there. Now, if the government itself really does not do it, so I have 3 or 4 suggestions to make. Where is it that we should really do? Since the schedule determines the entitlement, which is entitlement, if you read, anybody reads the schedule, is the basic minimum it says. It is not really enough at all, but the minimum of the minimum it says. I think it should be, there is need for class action suits in this country, not one individual. I think it's a wrong thing to really do. When the child rights are there, it is not to go for one child's right or one school's right. I think it's a more larger approach has to be made. And the suggestion, there is a provision when a fundamental right is violated to provide compensation. What is required, therefore, we should seek that for every school which is not provided with the basic minimum entitlement that have to be there for the child, all those children require compensation, not the individually, but in terms of a fund for that school for development. You cannot run away from that. Make the estimate to provide everything that is required and provide that fund. And it could be that fund could be accumulated and created as a fund for the school. I see this as a way of really getting out of this situation in which we are in the government schools, which are in really very, very bad condition despite that. Why? Asking people to come and then giving an affidavit to Supreme Court, we have found, is not effective in this country. 1995, Supreme Court passed an order saying that all children should be provided midday meals, hot midday meals. With great difficulty, the states are struggling to do. Later on, when the people went to court, Supreme Court saying that the children, how can children really study in a school without toilets and then without drinking water? So the Supreme Court again said and called all the chief secretaries to say that you have to really, why have you provided or not? Why have you not provided? You will not believe me. The chief secretaries have come to Supreme Court and given affidavit, written affidavit to Supreme Court. In our state, there is no school without toilet and without drinking water facility. Blatant lie, but it's a fact. But this is one thing that has happened. Therefore, we need to have a different approach. Second, I do believe that the Supreme Court, we should seek the Supreme Court to set up a monitoring committee. Just like they have set up a monitoring committee for food. Why can't we have the Supreme Court set up a monitoring committee for food? Third, I think we need to really clarify what are the aspects where the center and the state are responsible. As Kiran said that the SSA, Sarva Shiksha Abhiyan, has been declared as the vehicle for implementation of the Right to Education Act. If that is the vehicle, then it becomes a centrally sponsored scheme becoming a vehicle. So there is utter confusion at the state level today. The states don't really own this law. They say it is a central law, central government should provide. I gave that background to this, that the amendment to the central and state list is a very important issue. They say that no, it was made a central list, the concurrent list, and central law has been passed, central government should do. Why can't we really specify, classify of this entitlement that are there? These are 1, 2, 3, 4, which is the state government's responsibility. These are 5, 6, 7, which are responsibility of the central government. This would take us little further from where we are. And then the center and state need not really pass the buck and say it is not. The last, I think, I would like to say is that we need to bring back this idea that we put in the first draft of the Act, that every year there should be a report to the Parliament. What bothers me is that it is not just the state, it is not the executive which is not really bothered. The parliament is not bothered. Parliament made made an act for the children of this country, but parliament has never asked a comprehensive question. Why have they not held even one debate during the last 6 years on RTE? That is what bothers me. It is not just the state not doing it, which many things the state in the social rights do not happen in many other countries also, not very easy to really do. But why not the parliament take the state into question and say that why you are not really doing? I believe that's where it stands, and I wish that we really work toward that. I end by saying that what Kiran said, there is need for a much stronger public movement in this country in favor of education, which is very weak. We have an RTE forum, we have many other things, but they are all very weak, fragile forums. They are not, and I don't think we can really create we can depend on the middle class alone. I think it has also not happened, as I gave the example of parliament not discussing. The political class does not get involved in education. They do get involved in tribal rights and forest rights and all of them, but they don't get involved in education. And we need to really have a much larger public movement on this. Sorry, I took a little longer. Thank you very much for this.
Thank you. Thank you. Since there are many speakers, I don't know whether we want to do a round of like clarificatory questions or wait till the end. Wait till the end only. So let me invite Lucy Williams.
You should keep going with India.
Okay, I thought maybe we could do one on one or just the India first. Okay. Okay, so Jaina, what about maybe we'll get a legal perspective and then a civil society one to follow up.
Thank you, Kiran. And thank you, Dr. Govinda, for actually putting out many of the issues in context. It makes my job much easier. And I think, you've highlighted many of the real challenges, but I'll just kind of quickly give an overview of really the contentious legal issues around a better implementation of the right to education in India, and hopefully that will give rise to more thoughts and issues. So of course, we know, like Dr. Govinda pointed out, initially the right was not a justiciable right. It was under the directive principles under Article 45, which said that the state shall endeavor to make the right to education a fundamental right within 10 years. And it didn't happen, and it was only in 2002 when the amendment was brought about under Article 21A. Prior to 2002, of course, the Supreme Court, we've been placing so much reliance on what the Supreme Court is doing. The Supreme Court, in two of its landmark judgments, did lay down that the right to free and compulsory education is part of the right to life, and therefore did make it justiciable. We could have sought enforcement of the right to education even before we had Article 21A, because the right to life under 21 was expanded. But what happened? It wasn't as if people were rushing to court to seek enforcement of the right. Even as early as the 80s, when the Mohini Jain judgment was first pronounced, where the court said that the fundamental right to education flows from the right to life. It wasn't as if groups and organizations were rushing to court to seek enforcement. Then there was Article 21A, which made it a fundamental right. And following Article 21A, we had the Right to Free and Compulsory Education Act enacted in 2009. And I think this was, despite a lot of, questions about it, that is it a useful legislation, I still feel that it is quite a radical piece of legislation. For the first time, it mandates norms and standards for quality education. It mandates that every school will have a certain percentage of children from economically weaker and disadvantaged groups. That was to enforce equality. It was to enforce non-discrimination and diversity at the elementary school level. And it mandated many other provisions for equal and accessible education, such as to ensure that children are not expelled from school, there is no corporal punishment, there are norms and standards, pupil-teacher ratio, and all of that was there in the schedule that Dr. Govinda mentioned. And these are not easy battles. In South Africa, we're seeing that we're seeing how there's been, for several years, the battle in courts and with the government to have norms and standards, and we had it in the law. So I think to that extent, it's quite a remarkable piece of legislation. But of course, now the issue is the challenges are with implementation. I mean, we've had this, but if we see now what has happened after the legislation has come into force, initially, as soon as the legislation came into force, I just want to highlight some of the litigation around it, and I've kind of made it as first generation, second generation litigation. So the way I describe it, I think the first generation of litigation around the RT Act was actually challenging the Act itself. Because this led to a radical, I think, shift because for the first time it mandated, I mean, it was not addressing government schools alone, it mandated private schools to comply with norms and standards. It mandated private schools to admit children from economically weaker sections into their schools free of cost. Of course, they would be compensated by the state. But it actually meant that private schools had to provide for some children close to free education. Private schools did not like that. They did not want any interference from the state. Because they were actually not complying with norms and standards. And as Dr. Govinda mentioned, that we did have education laws prior to this, but my experience with education laws is that they were extremely inadequate when it comes to laying down quality standards. So most of the education laws that were there prior to the RT Act were really only for recognition of schools and very, very minimal standards of having teachers and qualification of teachers. It didn't talk about schools having playgrounds. It didn't talk about schools having libraries, toilets, the number of teachers. I mean, none of those standards were there. And I think private schools didn't want any interference. So the first round of litigation was where hundreds of private school managements challenged the law in the Supreme Court in two big cases. And the first was the Societies case in 2012, which upheld the constitutionality of the Right to Education Act. But it made a serious exception. It made an exception that private unaided minority schools that are religious or linguistic minority schools would be exempt from the Act because the court held that they had their constitutional rights under Article 29 and 30 of the Constitution to establish and administer their own schools. So religious and linguistic minority schools their rights were upheld and they were upheld over learners' rights to education. And they were given an exemption. And unfortunately, while their rights were protected mainly with regard to admission, that can you enforce religious and linguistic minority schools to admit children who are not from their community, I think, unfortunately, the Supreme Court extended the exemption to the entire Act, including the provision of norms and standards. After the Societies case carved out this exemption, there was another constitutional challenge in 2014. And this time, again, by private schools. And this time, the Supreme Court in the Pramati case extended the exemption to aided minority schools as well. So it, in fact, made the argument that minority schools, even when they get funds from the state, can still be exempt from complying with the right to education law. And so actually, you know, my view of rushing to the Supreme Court is slightly distorted by these developments. I mean, the organizations or entities who've been rushing to court are actually not NGOs or organizations or people wanting to enforce the law. The ones who are rushing to court are people who don't want to enforce the law. And the court is coming to their aid. And so we've seen over the last 5 years how the Supreme Court has actually continuously made exceptions to the RT Act at the behest of private institutions. So this has, and so this was the first generation of first round of litigation. After these issues settled, I think very slowly the issue of enforcement of the right to education is now coming up. It's very minimal, but there are cases where organizations, individual children represented by their parents are going to court asking for enforcement of provisions of the RT Act for providing quality education. There have been cases where safety in schools. There were cases where there was the Avinash Mehrotra case where there was a fire in a large school that was taken up to court, and the court said that the right to education includes the right to a safe space, a safe education. There was one litigation which was quite an important litigation in the Environment and Consumer Protection Foundation case, which unfortunately is not very prominent, but where the Supreme Court held that the basic requirements of toilets, teachers, midday meals, water, classrooms have to be provided by all schools, government, private, minority, non-minority, all schools, they have to be provided. Of course, these are, and affidavits were provided by all state governments saying that they have complied with it. There was a contempt petition filed because, of course, there was no compliance, but it has been hanging because I think the difficulties are that when you have the Supreme Court laying down an order saying all schools all over the country have to provide all facilities, it's impossible to monitor. Even if you have contempt petitions, how are you going to have enforcement, monitoring? I mean, of course, I'm not saying it's impossible, but it's extremely challenging. And you need organizations across the country to come together in the way the Right to Food case happened. They had a commissioner being set up. There were representations being made. There was a separate office of the commissioner being set up. But I think in the education context, that hasn't happened. So we've had this decision, and it's just pending. In Karnataka, we've had the Karnataka High Court take up a matter suo moto for looking at the issue of out-of-school children. And this was a matter that was taken up when the court read a news report saying that there were 50,000 children out of school in Karnataka who had either dropped out or who hadn't been to school. And the court took that up as on its own as a public interest petition to see that when you have when you have a Right to Education Act which mandates compulsory and free education, why is it that there were 50,000 children in the state who were still not in school? This petition actually led to a large-scale fact-finding exercise by the state government. The state government, with the help of NGOs and other organizations, conducted a house-to-house survey in the entire state to actually find out how many children were really out of school. And the numbers were shocking. The numbers were actually fourfold. So the numbers showed that there were about 2 lakh children out of school in Karnataka and not 50,000. And that led the court to ask the question is, how do you remedy this? And there were many organizations that got involved. We were one of them. And the court said that the court said that we are not going to pass orders. We're going to set up a dialogic process the way it has also been done in other countries, and set up a committee with the government involved. There were issues addressed as how can admission process be made better, how can migrant children, their education and dropouts be addressed. There was an admissions officer set up. So this was one experiment in Karnataka. But I think, and these are just some of the examples, but I do want to conclude with a few issues that I want to highlight. And I think some of the issues are that when you talk about enforcement and who's going to enforce, government is not enforcing, we need more class action, why aren't organizations going to court? I think till now, education organizations or NGOs have only been working with the government. There really hasn't been a history of litigation of taking the right to education to court for enforcement. The RT Act is very new. It was just passed 5 years ago. it was embroiled in challenges. And so I think it is going to, because education NGOs are working so closely with the government, there is great reluctance to go to court, whether it is a Supreme Court or High Court. And we still have to wait for some time before we get to that stage. When are they going to be ready to go to court? We've had the amendments made where the RT Act, even in Rajasthan, is weakened, but it's not being challenged because organizations are so entrenched with the government that they are not that comfortable to take the government to court. So that is one issue. I think the second issue is monitoring and implementation of court orders itself is a huge challenge. How do you design remedies where the problem, especially in India, even at the state level, the scale is so massive. When you have 200,000 children out of school, what kind of remedies can you design and how do you implement those remedies? And I think those are not impossible, but those are issues that need work. But I think things are improving. The courts are stepping in. And I think I would like to end this with in one article where Koski referred to do we go to courts and should courts have an enhanced role to play in enforcement of the right to education? Are they the right institution? Or when you talk of separation of powers, and he asked the question that if it's challenging, why? When you say the court may not be the right institution, you say compared to what? Are we saying that, are we seeing the government being able to handle it better? Not necessarily. And, sometimes you see that courts do have certain institutional strengths that can work towards this better. But I do feel that we need to move beyond just focusing on the Supreme Court. We need to go to the high courts. We need to have more organizations think of litigation and enforcement as think of it as active ways of implementation of the right to education. And I guess, yes, those are some of the challenges. Thank you.
Thanks a lot. Thanks a lot, Jaina. A very comprehensive sense of how the litigation is being going on in the country. Annie now will give us a perspective from the ground, being a social activist.
Thank you. It's really a privilege to be here to look at some of the issues that particularly confront the most marginalized children from the socially excluded communities. I think this whole having to come up here and talk really made me think about some of these things because we are really nowhere near litigation at this point in time. But I think even before going into the whole idea of litigation, I would just like to highlight some of the fundamental contradictions that exist for children from the socially excluded communities vis-a-vis even the Right to Education Act. I mean, like when I'm talking of socially excluded communities, I sort of think that people here would know the issues of the scheduled caste or Dalit communities who are supposed to be the ex-untouchable communities, and you would have, that's fairly a large population, about 250, 300 million people. Then you have the tribal communities who are again out of the mainstream of society, again fairly 100, 120 billion people. And then you have also other kinds of communities, particularly the Muslim minority communities, the nomadic communities. They do face particular forms of discrimination, social exclusion, and somewhere I think we have to keep coming back to these communities in any provision that we are talking about or any legislation that we are talking about. How are they being located and what are the issues that they face as far as getting access to justice? So 2-3 things I want to just bring up here is like Professor Govinda was talking about the schedule of the Act. Now, the schedule of the Act does talk about how a classroom should be, how a teacher should be, what is the water, but the schedule of the Act does not talk about the specific necessities of the socially excluded children. There is nothing to talk about what happens when discrimination happens. There's nothing to talk about scholarship. How is scholarship to be maintained and given? Or what happens when children from certain communities are not allowed to interact with children from certain other communities. So I think somewhere along the line, even though we have a schedule which we can go to court with, but that schedule has not taken consideration, or it has not really addressed the fundamental issues of children from socially excluded communities. So that's what I would like to first of all place, that while we have certain clear norms in the schedule, that this is the percentage of children ratio of teacher to child in a classroom, water, sanitation, whatever it is, but it has not looked at the issues that these communities and these children face. So I think even going to litigation fundamentally starts off with a problem. The second thing I would also like to bring up is the MHRD is supposed to be our basic education ministry managing the education of all children. But if you really look at the socially excluded children, MHRD has not really taken responsibility for these children. This is one of the contentions that we were just thinking about the other day, because if you look at scheduled caste children, the Ministry of Social Justice and Empowerment is supposed to be looking after their hostels, their residential schools, and their scholarship. And why should the Ministry of Social Justice and Empowerment be only concerned, and why is the MHRD not concerned? You take the tribal children, the Ministry of Tribal Affairs is supposed to be looking after these children. You look at the minority children, somebody else is supposed to be looking at. You look at juvenile justice, the Ministry of Women and Child is supposed to be looking after. You to look at the labor children, the Ministry of Labor is supposed to be looking at. So we're basically saying the MHRD has not brought these children under its purview as the constituency for which they should be really working. So I think that adds a fundamental problem, because we cannot go for scholarship to the Ministry of HRD. We will have to go to the Ministry of Social Justice. We will have to go for something else to some other ministry. So I think, and there is absolutely no coordination, no convergence between these ministries. And worst of all, the Ministry of Social Justice is not an education ministry, nor is the tribal affairs concerned about education. They are concerned about many other things. So I think even before we go into litigation, these communities have specific issues that even the right to education has not really looked at. And somewhere I think also, like, there may be certain other fundamental contradictions too, because when you look at civil society organizations that are working on the right to education, there is a hesitation to work on Section 12(1)(c). Because somewhere, and I can understand it, because somewhere there is a kind of a slight doubt, is working or promoting Section 12(1)(c) actually giving a backdoor entry to the private sector, and are we sort of allowing the state to move out from its responsibility? So I can understand that. But if I look at the community, I know the community has so many hundreds of problems that they are not really waiting for a holistic correction of all these problems. They are looking at the next step. Okay, can my child get an admission somewhere? Can I get a scholarship? Will I get an admission? So I think the community is not at this point in time looking at these very, very large questions, but it is looking at small steps that can do, and that is not in consonance with the, maybe the larger education activists, and there again is a kind of a contradiction. So I'm sort of just looking at, does the Right to Education Act and provide us the necessary framework and the necessary tools to really go into litigation? So that's about the Act and what it provides. And now I would also like to look at what the Act doesn't provide. I mean, like, I would really like to, I always keep saying that, the education department almost always continued to deny that there is any discrimination in education in schools. And I think the Act for the first time almost recognized that there is discrimination. And now now everybody does talk about discrimination, because the waters have gone beyond everybody else's head, I think, with Rohit Vemula and so many other things that are coming out. So discrimination is now not a contested form, but the Act was the first time really bringing discrimination into the fore and saying that it is an issue and that needs to be done. But then the state, the MHRD particularly, for the reason that I said earlier, it had no understanding on what that discrimination was, because it was not looking after the children from these communities. It was looking after children from maybe a general general mainstream mindset. The other thing I also want to look at is like equity measures. Now, socially excluded communities, many of them are first generation learners. And when they come in as first generation learners, neither the family nor the community have the kind of wherewithal to really support a child in school. And so there has to be adequate equity measures. And so now what do we fight for? Do we fight for that 150 rupees scholarship that is being given? Or do we say, no, we need 1,000 rupees scholarship because that's what the child will really need if it has to go to school? Do we sort of say that one pair of uniform is not enough, we need 5 pairs of uniform? So I think one is like, there are certain givens within the system, and that givens are not enough. That givens are not meeting the needs of the first generation learners, of these children from these communities, to be able to access a quality education. So there I think there is a fundamental difference between what the state provides and what the community needs in really making it equitable quality education. So I think here again there's no format for us to really go into a litigation. The third dimension, the next dimension I also want to look at is like, it's one thing to say that there is exclusion and discrimination, and it is another thing to say that we want inclusion, that we want dignity. And now what is the format for dignity? What is the indicators for dignity? What is the mechanisms for inclusion? I mean, these are really not laid out. These are not, even we ourselves are really not clear of what is it that we are talking about when we need inclusion, because that kind of a dialogue, that kind of a public space has never been there to talk about how do we create or how do we promote inclusion. So what I'm trying to basically say is like, while the RT Act is a fundamental right, is a justiciable right, but it has not taken the concerns or the framework of children of marginalized communities adequately enough within its framework for really providing the mechanisms and resources. And secondly, what I want to also say is like, if we're really talking of equitable quality education, it has to go beyond what the RT Act or the state provides, because what currently the equity measures that the state provides is just a symbolic name for some charity that it's talking about. It's not really looking at whether the child can really go and have a quality education. And thirdly, I think the justiciability in terms of promoting an inclusive society may not be the need for so many other people, but I think it is the need for marginalized communities, and there again we have no formats. So I'm really not coming up with solutions in that sense, but I think what I'm trying to sort of say is how maybe the Act and the state really needs to expand the thinking and bring these children into the center of its framework if we are able to sort of look at. And lastly, I want to say that, I do agree very much that all of us who come from the socially excluded communities, we've been so much concerned about civil and political rights. We've been so much concerned about forest rights and livelihood and food rights that most of us, the majority of us, have not looked at education or youth or employment as kind of, necessary frameworks for us to push our rights agenda. So it's very, very new. But what I see as a big potential is that there are a number of such organizations spread almost in every hamlet and every village. So there is the potential of working with these communities, working with these children, and these young people who are the first generation learners are also the role models of the younger children. And I think that is the great potential that we can really look for in creating this kind of a mass mobilization in building filling some of the gaps in this act and its implementation. Thank you.
Thank you very much, Annie. Esteban, I may ask you to go next.
Okay, first I want to thank you, the CPR, NASDIC, everyone that put together this conference panel, everything, and you for joining us this afternoon. I'm pretty sure that you are very tired at this point, but I'll be short. The reason I'm sitting here is because I was one of the lawyers, is basically because I was one of the lawyers that litigated before the Colombian Constitutional Court a case on the economic accessibility to the right of education, in which basically we challenge a national law, our general national law of education, an article of the general law of education, which allowed the government to charge for education in public institutions without distinction of the level of education. Basically, even they were charging even for basic primary education. The people that are in the inner circle have known about this case because I have talked a lot about it before. So I decided not to discuss fully the case, but I will be happy to do it in the Q&A. What I wanted to do is, like, based on that experience that I have had on the right to free education and on the economic accessibility to the right of education, to present some of the challenges that people that work with the right to education, and I think not only in Colombia, but in India, South Africa, Brazil, and other jurisdictions represented around the table, encounter when we work with the right to education. And this perfectly resonates with what which had been said before by all the panelists, particularly describing the Indian experience. So the challenges that what I want is very briefly in the time that I have, like, to present some of these challenges, but to say that, of course, these are not the only challenges to start, as we have seen in the previous presentations. But it's important, and I do really believe in these dialogues, particularly between countries with progressive constitutions like the South African, like the Indian, in the Colombians, like to think further in ways that we can assess these challenges. And I think that's the value of that the people around this table is here, is like, how can we together can make significant contributions from a global South perspective to think about these challenges. And not only talking, I'm not talking only about South Africa, India, Colombia, I repeated also India, and even countries from the global north that can tell us a lot and that have their own challenges with the right to education. So I divided these challenges first in structural challenges, legal challenges, and political challenges. Again, I'm not going to talk about all of those because I don't have enough time to do it. First, the structural challenge, and I think that for people that work with the right to education in a country like Colombia or in India, as Kieran was saying at the introduction, this public-private provision of the right to education is a very sensitive topic. A Colombian legal sociologist, Mauricio García Villegas, and his co-author, Jose Espinosa, they produced a very interesting book a couple of years ago that it's called Separate but Unequal. And basically the conclusion that they arrived, they basically analyzed the development or performing of students in the Colombian national test that the students have to take when they are in high school. And what they found, of course, it was that there was a much better performance by the students that were educated in private institutions in Colombia vis-a-vis those who studied in public institutions. So the main conclusion was of the study was that the educational system doesn't only better educated upper classes, but educates them separately. The rich not only receive better quality education, but also an exclusive education. The study that I recommend, unfortunately, it's only in Spanish right now. So far, it's called Separate but Unequal. But it illustrates that structural challenge that we encounter with the public-private provision on the right to education. But we also have legal challenges, and some of those legal challenges arose in my own experience with the right to education, and it's the complexity of the right. For people that work with the right to education, most of you have known about the 4A framework to analyze or to assess the right to education. The idea that the education has to be available, accessible, adaptable, accessibility, adaptability, acceptability, which is the idea of quality and availability. So the right to education, it's a complex right. and we have like to be fully, as any other social and economic right, we have to be fully aware of that complexity. And part of what I learned working on my case on the economic accessibility of the right to education is that some aspects of the right to education are easily justiciable, or easy to promote a litigation in order to enforce it, as it was the economic accessibility of the right. But some other aspects of the right are not. I mean, like the way to pursue fully the protection is definitely not the litigation. So I remember when I first started working on the economic accessibility of the right, the people were telling me all the time, but the problem in education in Colombia is not that the education is not free, but it's an education of poor quality. But I showed them that 80% of the small municipalities in Colombia were still charging for that poor quality education. So, and sometimes even progressive sectors of society do not understand that distinction and that complexity of the right. And important in this, sometimes, and here maybe this is something that we haven't fully discussed in the table, it's important the role that the international human rights law play in this aspect, in the legal aspect of the right. For instance, on the economic accessibility of the right to education, the international human rights law was on our side because it was much more clear regarding Colombian obligations to the right to free education. But it's not always the case for all the aspects of the right. For instance, regarding the acceptability of the right to education, the international human rights law on the subject is not that clear. And finally, because time it's almost up, the political challenges. And here we have mentioned a lot, and that's why it's fascinating, like to have people on the table that do this work directly with communities. I think that what I will say is that we have to understand that regarding education and the protection of the right to education, we encounter with a field with many actors and interest involved in that. So for instance, when we decided to work on the case for the right to free education, we definitely stand with the families and with the kids, with the children, of course. But it could be the case that that some people stand like with the professors or like other aspects or other actors of the right, or involved in the right to education. So the political mobilization is not easy in a field where there are so many actors and interests involved. And finally, I want to say a word about politicians and education, because politicians tend to use the discourse of education as it's almost like a sexy topic, especially in campaign times, but when they get to government, at least that is the Colombian experience, you don't see really the advance in the protection and the effective protection of the right. So I think that the challenge that we encounter in that political aspect of the right is that the policies on the right to education will be really state policies and not exclusively government policies. And the distinction here is that it's not only the government that it's empowered, the one who's gonna or should promote a particular vision of education, but really state policies. And the example that I would like to put on Colombia right now, it's a program which is called Ser Pilo Paga, which translates like to be smart pays off, which is a government program that it's not in any law of the Republic, and basically wants to facilitate access of students to university education. It's a very small program still. They are starting And the idea is that students can go to university, to any university in Colombia, not only public ones, but private ones as well. But the thing is that it's a government program to facilitate access to education. But we don't know who's going to be the next president or the next minister. And this is not right now a policy of state to facilitate access to education. I will leave like that. The only final thing that I will say is definitely the way we address the legal and political challenges. We could address like other structural challenges that the right to education have in our societies. Thank you.
Thank you, Esteban. I'll ask Kevin now to speak next. Or Lucy?
I was hoping you would do it.
Well, Kevin and I both come from the United States, for better or worse. And in the United States, we do not have a constitution that has been interpreted as having the social and economic rights in it that is in other countries. But we do have a few state constitutions that have the right to education contained in them. And so one of the things that we have been trying to work on is what we call bringing human rights home, and particularly in a couple of states in the right to education. For a couple of decades in New York State, there has been an ongoing case called Campaign for Fiscal Equity versus the State of New York. Because Article 11, Section 1 of the New York Constitution guarantees every child a sound basic education. Now, I really appreciated everything you said, Annie, because most of our education funding is not state funded. Most of our, or much less nationally funded, it's not. Most of our educational funding is locally funded and based on property taxes. And that means that wealthy neighborhoods have high property taxes and have relatively good public schools, sometimes excellent public schools. And poor neighborhoods have low property taxes and have absolutely lousy schools. And unless you have a provision like this in the state constitution, you have nothing to protect or help those poor neighborhoods to get additional funding unless you can pass an initiative that will create additional funding for those low schools. So exactly what you were talking about, Annie, there's no mechanism for bringing up the schools that have the poor neighborhoods in them. In addition, we don't have a Right to Education Act. Well, we have some things like that, but we don't have anything that gives the standards that you're talking about here. So when you take something like what was contained in the New York Constitution, the court has to give meaning to it. And the court, over 2 decades, through the Campaign for Fiscal Equity Act, first said that it consisted of at least the basic literacy, calculating, and verbal skills necessary for productive civic engagement. That's how they initially did it. And the Court of Appeals is the highest court in New York. And then they clarified to say that it also had to cover skills needed to sustain competitive employment and acquire higher education. Now, you might think that's pretty good. And in the 2007 session, the New York legislature enacted funding. They went through weeks of trials to determine what that actually meant and what the cost would be and all that. And the legislature said this is what it's going to cost, and then the legislature enacted a budget to pay for it in 2007, and then they promptly turned around and put forward obstacles to stymie the funding. So most of the funding for those progressive things never came into being. and because of separation of powers doctrine in the United States, we have a very hard time with the courts ordering appropriation funding. Now, but as a result, two things came out of it. And the lawyers for CFE feel they've made great progress. They feel like they've established a lot of standards. They feel like they've mobilized. We had a big discussion about civil society earlier, and so some people think civil society is a positive thing, and some people think civil society is going down the tube. So I'm not going to use quite that word, but they think they mobilized a lot of advocacy groups and grassroots organizations to move forward the right to education. And in addition, additional cases have been filed that have a much narrower focus than this big, and I kind of want to raise that as a strategic issue. A new case, the Maisto versus State of New York case, was filed in 2008 to hit some high poverty, small city school districts and to target those and see if something could come out for those. And then another case that has just recently been filed, and I quite frankly cannot even tell you all about it, is the New Yorker for Students' Educational Rights versus State program. That's, again, a much more targeted program. Okay, that's in New York, but I think even some of those of you who are from the U.S. are going to be surprised the other state that has been litigating the right to education cases, and it's been Kansas. Now, Kansas is not known for radical progressive litigation, but it has been litigating the right to education since the early 2000s in a case that is called the Luke Glannon case. Kansas has an Article 6 that sets up its right to education, and in Article 6b, it says that the legislature, the state legislature, not local property taxes, shall make suitable provision for finance of the educational interest of the state. So in the early 2000s, there were 4 cases that were all called the Montoy cases, Montoy 1, 2, 3, and 4, where they gave meaning to that phrase. And they decided it included 2 aspects. It included equity issues and adequacy issues. And in the Montoy case, the legislature in Kansas actually appropriated $755.6 million and it went through and added it to the budget to equal, and the whole point was to equalize the budgets between the neighborhoods that had poor schools and the neighborhoods that had wealthy schools, that came from wealthy neighborhoods. And that was the equity part. What was included in the equity was it was still based on property taxes, but the state had appropriations for capital outlay state aid payments that they would give to poor neighborhoods, poor school districts, to equalize them. And then they also had supplemental general state aid payments that they would give for some of the very things that Annie was talking about. What do those poor schools need that they can't have otherwise? So then the Kansas Supreme Court decided, okay, the state has met these constitutional provisions, and so they ended the Montoya case. And then the recession hit in the United States, and Kansas at the same time elected a very conservative governor and legislature. In the United States, that's usually, not always, but usually the Republican Party. And that was what happened in the state of Kansas. We still have a Republican governor and a Republican legislature in the state of Kansas. And so that's when the Luke Glannon case, was just filed in 2-3 years ago. And it went back up to the Supreme Court in 2014. And the Supreme Court of Kansas again said that the legislature had not met its constitutional duty under equity or adequacy. And after the Supreme Court ruling in 2014, the legislature added $130 million to fund the equalization problems. But it went back to the lower court, and they said you still have not met the adequacy issues. And I won't go into all the details of what is equity and what is adequacy, but they weren't paying out the capital outlay payments, and they were reducing the supplemental general state aid payments. And now they're at a standoff. The legislature said we're not going to meet the adequacy payments, and so just last month, the case went back to the Supreme Court, and the Kansas Supreme Court has said, I'm giving you till June to come up with the money for the adequacy payments. And if you don't, I'm going to shut the schools down. I'm going to let you go in through June, and otherwise I'm going to shut the schools down for next year. So they're playing hardball right now. They're saying that we know we cannot order you to appropriate, but we're telling you, it's almost like in Colombia you have the unconstitutional state of affairs, or they're saying you're operating under an unconstitutional state, and therefore even if you don't correct your unconstitutional state, we're going to shut down the public schools. So that's as of last week. We'll see what happens. Now I want to say one more word, and then I'll turn it over to Kevin. I'm hoping some of our South African friends will talk a bit about what has gone on in the right to education in South Africa. I only want to mention one case that I know just happened in December when the Supreme Court of Appeal and it's reached a decision. And again, this kind of raises the issue of how do you frame relief. The Basic Education for All is an organization that works on education. Section 27 is a group of lawyers in South Africa that bring a lot of cases regarding the right to education. They brought the case on behalf of BIFA, that's Basic Education for All, in the Limpopo district, where they were not getting textbooks for all the students. And they won in the High Court. The Minister of Basic Education appealed, and just in December, the Supreme Court of Appeal ruled that the government had violated the right to education, equality, dignity, and I found this interesting. Section 195 of the South African Constitution is the basic value and principle of public administration. And I want to raise that for our Indians in terms of public administration and questions that I'm going to raise with you about public administration in the school system that I just have questions about. But that the delayed textbook delivery violated those things. And kind of also, they don't have directive principles and fundamental rights, but they ruled in that case, relying on an earlier case, that the right to education in South Africa is immediately realizable and is not subject to progressive realization, which most of the other rights are. And they, interestingly, rejected that the government's arguments that budget constraints were a defense, and they rejected a separation of powers argument. So it's I've been in communication with the BIFA people and the Section 27 people, and they all feel like it's a very significant case. And they said that the Minister of Basic Education, for the first time, has acknowledged publicly acknowledged an obligation to ensure that every learner has regular textbooks. And so they feel quite positive. You guys may not feel it's as positive as they do, but they feel quite positive about it. So I just kind of wanted to raise some of those as issues. Mm-hmm.
Thank you. Thanks, Lucy. Kevin.
Thank you very much. Thanks very much. It's a special privilege to be the seventh person in a seven-person panel at the end of the day. I want to start by thanking everyone who put together this event, which has been amazing so far, and I'm sure it's going to become more amazing over the next couple of days. I also want to thank all of you for the extraordinary effort that I know it requires to maintain attention in a conversation like this after a long day of such conversations. As the last speaker, I want to exercise another little privilege, which is I want to ask you all to stand up with me at your seats for just 1 second. Will you all stand with me for 1 second? If you can. Put our hands all up in the air. Oh, thank you. Can you even stretch back a little bit? Now clap for all of us. Thank you. With that as an introduction, I want to speak about one very specific aspect. I would consider it to be a unique aspect of the conversation, the struggle for the right to education in the United States. In some ways, it's a uniquely U.S. thing called the charter school movement. And I'm just curious, are people in the room familiar with that movement? Would you just raise your hand if you know about this movement and have some information about it? It's mostly U.S. folks, not surprising. I want to start out by saying that, just by way of background, that I've heard a couple references in the panel to the notion of private sector participation in the delivery of public education, which in our discussion in the United States is becoming an increasingly central theme in the conversation. And it generates my interest in sharing this reflection about the charter school movement with you. And by that, I mean the diversion of public resources to support the private delivery of education services. I don't know to what extent that's an issue here in India. It's a very big issue in the United States, and it sounds like in Colombia as well, it's an issue. That's kind of the background for this. The other piece of background is the important point made by Lucy that there is no notion of a right to, or there's a notion of a right to education, but there's no existing right to education in the Constitution in the United States. Our distinguished moderator in the beginning spoke of your situation here in India as rights advocates facing a situation of a right without a remedy. I think you could describe our situation in the United States as struggling for a remedy in the absence of a right in some way. That sort of characterizes our situation. I intersect with this conversation from one perspective in my role as in work with the Human Rights Center at Northeastern. I've also been a parent. I'm now in my 16th year of being a parent of public school children in the Boston public school system, and sort of kicking and screaming, I've been dragged into parent organizing and parent advocacy around the quality and accessibility of those schools. So I'm speaking as much from that perspective, I suppose, as I am somebody involved at Northeastern. Or maybe I'm speaking from the way that those two things come together. I think people are probably aware that there was a very important social movement for civil rights in the United States that was built very much around a demand for equal and accessible education. For decades, that was an important driver of change in education. And litigation around education was at its peak in terms of effectiveness, I would say, when it was riding the quest of that wave of social movement. After a couple of decades, the sort of force of that social movement began to ebb a little bit, and litigation became more the center of the movement rather than an accompaniment of a social movement. And at around that same time, the President of the United States, whose name at that moment was Ronald Reagan, famous in some quarters, ordered a commission to look into the state of education in the United States. And it came out with a very provocative report called A Nation at Risk, exclamation point. And the idea of that, you may be surprised to know, was not that our country was at risk because we were denying a large percentage of the population their legitimate right to education. The concern expressed in that dramatic report was that the miserable condition of the education system in the United States was affecting the global competitiveness of the United States, that we would no longer be the dominant economy in the world unless we did something about this mess of an educational system. And that generated the initiation of a process that's come to be known as education reform in the United States. A little bit of a misnomer, I think. But it's a thoroughgoing, I think it's not too much to say, almost a reinvention of the idea of the education system in the US. And it's been driven by three basic principles. There are many principles involved, but I think you can understand it in terms of three lead objectives. The first of those objectives is to institute high-stakes testing as a way of measuring the success or failure of all educational endeavors. Yesterday, Natalia was lamenting the fact that in the discussion about the rights of disabled persons in Colombia, the discussion about indicators had reduced the consideration to 10 indicators, leaving out a great deal of the experience and lives of disabled people. In the United States, the discussion about education has been entirely reduced to one indicator: the performance of children on standardized tests, with all the limitations that that implies. The second thing that's come with this system, or this idea of education reform, is reconceptualizing the idea of discipline in the classroom, gaining control over the classroom and creating a kind of no second chances discipline system in the classroom, bringing control to that situation. And I think where that's taken us is now, if you look at the education debate in the United States, there's a very common discussion or a common term used to describe where we've come to, and it's called the school to prison pipeline, with the idea that the way that we're structuring schools is somehow feeding the disease of mass incarceration in the country, the existence of so many millions of people behind bars, that there's a connection between that and the way we're talking about reforming the education system. The third and the most powerful driver of this education reform, I would say the most powerful, is one that you're familiar with here, the idea that the market, if only we can bring the concepts of the market into social policy, all ills can be resolved. Right? So the idea there is what's missing in the system is school choice. Parents do not have, there's not enough of a market of competitive options in education existing, so we need to find ways to create more of those options and put the public school system in more competition with other alternatives. So based on that, a whole series of reforms have developed. There's been it's a 20-year process now, at least 20 years. And very recently, in the fall, when a very important federal education bill was passed, President Obama said, very proudly, that at a moment when national politicians in the United States can agree on almost nothing, I'm proud to say that we're standing here as Republicans and Democrats agreed on what we have to do about education. That education reform and support for that is one of the very few things in the country that we're able to get bipartisan agreement. I think he's correct about that, but it's a sad correct that he is. So I want to just, based on that background, just draw one little piece, which is this charter school movement. And charter schools, very simply, are privately managed schools that receive public funds to operate schools run by private boards of directors. It's a magical thing that when I talk with Latin Americans about it and they sort of scratch their head, it's a concept that's difficult to imagine. But through legislation, there was a space created beginning in the early 1990s, and as Lucy said, everything in education happens at the state level. The state of Minnesota, one of the most progressive, quote-unquote, liberal states in the country, was the first state to pass a bill saying you could have these schools. Private groups could apply for charters. A group would be authorized within the state to issue these charters. Once the school received the charter, it would receive money from the state for every student that it could attract to its school. So that money no longer would go to the public schools, it would be diverted to this charter school. And they've done a very good job of branding themselves as public schools. But I think if you have a school that's run by a private board of directors, it has no public oversight whatsoever, it's difficult to understand. In many cases, they're owned by private institutions, private companies. It's very difficult to understand how we can conceive of that as a public school. So when this idea came in the 1990s, almost nobody paid any attention to it, right? It was sort of thought of, here's an idea, it's another one of these things governments come up with, it's stuck on an obscure bill, it's really not going to mean anything. But to our surprise, it's meant quite a bit. From the first passage of that law in 1991, now 43 states out of 50 in the United States have passed bills creating a legal space for these charter schools. I don't know if you know how amazing that is, but I think it's safe to say that you couldn't get 43 of the 50 states in the United States to agree that the sun was going to rise tomorrow. So it's quite remarkable that they have somehow pulled together a political coalition that's delivered 43 state-level laws creating these schools. The day that the law was passed in Minnesota, there were 0 schools in the country that used this model of diverting public funds to essentially private schools. At this moment, of course, because it's decentralized, nobody knows exactly how many there are. But there are something on the order of 7,200 of these schools in the country, and they're educating over 3 million children. I know in the Indian context, 3 million children may not seem like very many, but in the US context, that's an enormous, to grow from nothing to that in a relatively short period of time is an amazing thing. And again, remember, for each one of those children, the money is diverted out of the public coffers and into the private system. Just to give you a sense of, in Massachusetts, our state, which is one state that's been kind of slow in terms of charter growth. In fact, we're being criticized for being too hesitant to adopt this new system. Last year, there were $407 million diverted out of public education budgets into private charter schools through this mechanism. $407 million, according to my very back of the paper calculation, would be 26,900 million rupees in diversion from the education budget of one state into these private schools. I don't know what that scale of money is in the Indian context, but it's a lot in the United States. So how do we think about these schools from a human rights perspective? Really, our work at Fergie has been about trying to analyze this phenomenon, which is a very interesting phenomenon in the United States from a human rights perspective. And there's a lot to be said, which I obviously don't have all the time to say, about what the experience of these schools have been. They have had tremendous success educating certain children, right? And the children that they're attracting are almost 2/3 of the children in charter schools are African-American students. They're not, 90% of the school districts in the country have no charter schools. So all of those schools I mentioned are concentrated in 10% of urban districts that are generally high poverty districts. They've been very successful at attracting especially African-American children to their schools. And for many of those children, they've shown extraordinary educational results. And there can be no disputing that. But they've also had a very high rate of suspension and expelling students who can't conform to their educational process, right? So what does that tell us from a human rights perspective? One other thing first. A huge issue in the public education system in the United States is providing adequate education for children with special needs. The other thing that's indisputable about charter schools is they do not attract large numbers of children with special needs. They do not serve those children. Another huge issue is English language learners, students who don't have English as a first language. They also don't attract those are the two biggest and most expensive groups of students in the system that then become concentrated in the public system, right? Because charters don't take them. So in short, from the human rights perspective, our analysis of this is you have to recognize from a human rights perspective that these schools have attracted large numbers of students from historically disadvantaged and discriminated against groups in the United States and provided them with an education that their families believe they couldn't receive in the public schools. From a human rights perspective, this is a gain. We must acknowledge this in the charter school system. But there are also many other counter issues to that, right? All those resources that would have been going to public schools are not there anymore. At the same time, the public schools are being asked to educate the children that are most expensive and challenging to educate. So that the effect of the growth of charter schools on the rest of the system has been quite negative. And this also is beyond dispute. And even the charter schools themselves do not dispute that. So from a human rights perspective, we feel the need to look both at those most discriminated against groups and take the perspective of what's the impact of this policy on the system as a whole. So from that perspective, we see the charter schools as extremely problematic. And their continued growth is something that from a human rights perspective cannot be accepted or recommended as a policy. So I'll just conclude by saying that, again, this is an important and politically a very charged thing because because of who they've attracted, they've built a kind of coalition of support behind their schools that's very difficult to challenge, right? But over the last few years, given the obvious effects on the overall public education system, there's more and more of a challenge to that. So last year in Massachusetts, for the first time since the passage of the original bill, an effort to expand the number of charter schools that could be in the state failed, right? And this is beginning to happen around the country. In the state of Washington, there was a long-term court case that challenged money to charter schools on the basis that their state of Washington's constitution only allowed public funds to go to public schools. And that case was won. So for a short period of time, there could be no charters in Washington. Now, the state has just gone and passed a constitutional amendment so that charter schools are, again, possible to deal with. What I want to end by highlighting is that there is an emerging social movement with very much the character of the civil rights movement around education in the past that's not only challenging charter schools, it's challenging the entire educational reform apparatus that I mentioned in the beginning. It's a social movement in its infancy. It hasn't shown tremendous results, but I think it has tremendous potential. So it's something that I'm very pleased to be able to share with you all, and hope we have some opportunity to talk about it either in question and answer and other discussions outside of this. Thank you.
Thank you, Kevin.